The purported notice of association was filed without the knowledge, authorization, or consent of plaintiffs or their attorneys, after they had already terminated his representation. I only learned of the application through concerned friends and family who saw references to the application on the internet. You don't do that, Mr. Hook.
This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below.
So last week we talked about the attorney for Linda Oliver and Alan Baker. Who was that? That was a man named Hook, Christopher Hook. He has now filed something new. Christopher G. Hook, attorney of record for plaintiffs herein hereby associates Matthew B. O'Hanlon of the law firm Barnes & Thornburg, LLP, as co-counsel for plaintiffs in this matter. The name, address, telephone number are as follows, and let me just look myself before I go and put it here. And yeah, he gives the name, address, telephone number, and then signs it. So really, really simple. No big deal. Substitution or association of counsel, right? No big deal. Well, that would be true if this wasn't already a remarkable case where the attorney had the outburst where he called Allstate attorneys all sorts of names, very inappropriate things that we ended up having to bleep out, and even bleeped out. YouTube still demonetized the video. We requested review, and we, I think, did get our monetization back, but of course after the peaks and all that. So what happens next then is plaintiffs Alan Baker and Linda Oliver object to the unauthorized notice of association of counsel filed by Christopher Hook. Like, just on its face, it tells you he wasn't allowed to file that. So what's happening here? Plaintiffs Alan Baker and Linda Oliver, the insured, through their newly retained counsel, Barnes & Thornburg, hereby object to the unauthorized notice of association of counsel submitted by their former attorney, Christopher G. Hook. The purported notice of association was filed without the knowledge, authorization, or consent of plaintiffs or their attorneys, after they had already terminated his representation. You don't do that, Mr. Hook. I hope for his sake it was some kind of giant misunderstanding that he has in writing and can support. I really hope so. Barnes & Thornburg has not agreed to associate in as counsel with Mr. Hook in this action. As such, the court should disregard the purported notice of association. So then, we have the declarations that are filed in support of Alan Baker and Linda Oliver's statement. Alan Baker declares he's one of the plaintiffs and he would testify if he was called as a witness. Since 2009, he served as an associate dean at USC School of Cinematic Arts. Interesting. Where he was responsible for developing new and overseeing current international programs. He has been a co-principal investigator of American Film Showcase, a multi-year grant from the U.S. Department of State that sends American filmmakers and American documentary films to countries throughout the world for workshops, festivals, and programs. Prior to coming to USC, he worked for 25 years in television programming as vice president of 20th Century Fox Television and Paramount Television. He has reviewed Allstate's ex parte application for various orders, including an order dismissing this action based upon statements and conduct by my former counsel. Mr. Hook did not notify us about the filing of the application. In fact, I only learned of the application through concerned friends and family who saw references to the application on the internet. How horrible is that you would find out your attorney filed terrible things on your behalf in your name, and you found out from the internet? Your attorney wouldn't even tell you. The opposition filed by Mr. Hook was filed without my knowledge or approval. I do not condone his statements or conduct. Such statements and such conduct does not represent me or my wife, who are wholly unauthorized by us and are in no way acceptable to us. During the time Mr. Hook was apparently engaging in this conduct, we were out of the country as part of a work trip. Mr. Hook's statement and conduct have put our professional and community reputations that we have worked so hard to achieve at risk. Upon learning of Mr. Hook's statements and conduct as reflected in the application, we promptly terminated Mr. Hook's representation of us and retained new counsel, and they declare under penalty of perjury. I'm going to skip forward, and Linda Oliver's says the exact same thing, except for what she is. So, and I don't really want to dive into people's personal history too much. So then here is the objection to the unauthorized notice of association of counsel. Plaintiffs Alan Baker and Linda Oliver hereby object to the unauthorized notice of association of counsel submitted by their former attorney. The purported notice of association was filed without their knowledge, and they had already terminated his representation of them. They have not agreed to associate in as counsel, and as such, the court should disregard. So that's a really interesting update. Let me see what else is going on there before I respond to it and react to it. So yes, the judge has not ruled on the motion to dismiss yet, but I imagine there is going to be a brief or argument made that the plaintiffs do not believe that they should be that they should be punished, that the plaintiffs should not be punished for Mr. Hook's conduct because that conduct was not authorized by them. And I hope the judge will probably have to hold some kind of a hearing, or maybe Allstate will agree to some sort of stipulation since there's new counsel now and they're going to be treated with respect, just basic respect. So I think maybe that's the end of Mr. Hook's involvement with the case, and maybe the beginning of Mr. Hook's future disciplinary complaint or action, as I can't imagine a client or attorney not filing a complaint for something this egregious. So I expect his bar card or his law license is going to be threatened in some way. And if I recall correctly, so did Pope Hat. Let me see here. Yes, so Pope Hat then writes about the same thing. And let's see what his reaction was. Pope Hat, of course, is Ken White, a former prosecutor in the Southern District of New York, I believe. And he says Hook had filed an association of counsel, new attorney filed an objection, etc. And he thinks that we're going to see a repeat of the Prendle Law case where Judge Wright asks him to appear and explain, and he'll have to take the Fifth Amendment in order to protect himself. And of course, this is Judge Otis Wright down here. That's what he looks like. He is a very nice man. Obviously, he wrote the Star Trek opinion. No, I don't imagine anybody could understand Star Trek in such a manner and not also subscribe to Gene Roddenberry's morals. But I don't think he's a man you want to trifle with, if you know what I mean.
I mean, the thing is that this is what we were worried about with Leibowitz, right? Like, we were kind of worried about Leibowitz because the one element that hadn't been discussed by the judge was whether or not he had adversely affected his client with his lie, right? And so in this case, we see exactly that. Somebody who's misbehaved in such a way that has affected their clients.
So there was a objection. Let's see if this is anything. I have pulled up here his opposition to defendants, Allstate, ex parte application for dismissal. This is something we weren't able to cover because he filed this right before we dropped the story, I believe. Plaintiffs Alan Baker and Linda Oliver hereby oppose and object to the meritless and untimely ex parte application. Plaintiffs respectfully request the court to consider the arguments and evidence submitted herewith, deny Allstate's application, reverse the order setting an order to show cause, and place a hold on depositions and award monetary sanctions against Allstate. Whoa, what? Award monetary sanctions against Allstate? Are we kidding?
Whoa.
All right, let's continue. He says, the ex parte application filed by defendant is a desperate and improper attempt at gamesmanship. And just so you're aware, we're talking about this one. We're talking about this one. That's what he's upset about. filed without any attempt at informal resolution on the eve of a stormy Thanksgiving holiday. Defendants' papers were prepared and filed without regard for and in violation of applicable local rules. Applicable law, local rules? I haven't seen that phrased that way before. For the improper purpose of delaying depositions and frustrating the administration of justice. Defense counsel's sole evidence in support of their application is a hearsay reference alleging the undersigned told defense counsel, "I know where you live," during settlement discussions. Plaintiffs submit this is not good cause for a motion, let alone ex parte relief intended to be availed by litigants facing extraordinary circumstances. He's so close. It's intended to be availed by litigants facing extraordinary circumstances. He's so close. He almost has it. He just has to realize that he is an extraordinary circumstance when he acts like that. Settlement discussions and all litigation-related speech are absolutely privileged under California Civil Code and inadmissible as evidence under California Evidence Code. Well, inadmissible as evidence to prove something else. Not, very likely, not inadmissible as evidence to prove misconduct by an attorney. Plaintiffs respectfully request the court reverse its order staying depositions and setting an order to show cause on defendant's application on December 16th, 2019. This is a first-party bad faith insurance case filed in the Superior Court of California, County of Los Angeles, August 13th, 2019. The complaint was filed on behalf of two elderly homeowners who reside in Hancock Park and suffered a massive water loss on September 20th, 2018, which destroyed nearly half of their home. Unfortunately, their misfortune turned into a nightmare when their good hands, Allstate, you're in good hands, insurer assigned their claim to an adjuster who did not understand the benefits plaintiff purchased as part of their deluxe homeowners policy. Instead of cooperating with the insured to make available up to $1.7 million in extended replacement coverage to reasonably repair the damage, Allstate's adjuster attempted to bludgeon these elderly customers into accepting pennies on the dollar of what they were owed. Prior to filing this lawsuit, the undersigned wrote to the adjuster to try and resolve the matter, attached as a copy. No response was received. The complaint filed in state court on August 13th includes 7 causes of action, including tort claims against Allstate and the adjuster. On or about September 17th, 2019, the law firm Shepard Mullen Richter Hampton filed papers noticing removal of the action to federal court claiming diversity jurisdiction. Plaintiffs admit that the adjuster was a fully disclosed agent acting in the course and scope of his employment with Allstate. For this reason, plaintiff cannot state any valid claim against Mr. Carrasco, the adjuster. On September 24th, Allstate filed a motion to dismiss the plaintiff's 3rd, 4th, 5th, 6th, 7th causes of action. On November 12th, plaintiffs filed an opposition to the motion to dismiss and removal papers filed by the law firm, because there was no diversity jurisdiction and the removal was simply a continuation of bad faith tactics. Okay, I don't see it as bad faith tactics like already, like just by itself. I would think it would only be bad faith with something more. Just filing a notice of removal because you believe that you have diversity jurisdiction, you're allowed to be wrong about that. It might even be allowed to be a delay tactic, but if you don't have proof that it was solely a delay tactic, and even then, that's on the edge of bad faith. I mean, it is bad faith to delay and be frivolous and all that. Don't get me wrong, but most courts aren't going to be really upset at one thing, one delay, it's usually like a repeated and egregious pattern of conduct that really gets the court's attention and ire. Plaintiff's counsel, November 13th, deposed Robert Romero, the supervisor of the adjuster. The deposition was concluded at approximately 4:30 at the request of Mr. Romero, who was tired, and defense counsel Mark Feldman with the promise to make him available again in 60 days. At no time did Mr. Feldman express to the undersigned an opinion that Hook was behaving inappropriately towards counsel or the witness. A true and complete copy of the transcript of the first session of the deposition is attached. Defendant Carrasco's deposition was taken on November 15th, 2019. The deponent was represented by Mr. Feldman. The deposition proceeded without incidents into the mid-afternoon, and then the witness grew tired after less than 4 hours. 4 hours is a lot. However, the Federal Rules of Civil Procedure allow 7 hours. And I would usually conduct that as 3.5 hours in the morning and 3.5 hours in the afternoon. In reality, I've never actually seen a deposition go a full 7-hour day, but that's what the rules allow. Plaintiff's counsel agreed to continue the deposition to a mutually convenient date. At no time during the deposition did anyone indicate that the undersigned was threatening the witness or making him uncomfortable. A true and complete copy of that transcript is attached. During Carrasco's deposition, a policy limits settlement demand was extended to Allstate. This demand was left open until the day after the deposition, as set forth in further details in the supporting declaration of Christopher G. Hook. Following Carrasco's deposition, it was the opinion of counsel that clear and convincing evidence existed, giving rise to a high probability claim of punitive damages against Allstate Insurance. After such date, plaintiff's counsel began aggressively negotiating a settlement with defense counsel. Unfortunately, defense counsel decided to ignore Mr. Hook, refusing to take his calls or respond to his voice and electronic mails so Hook is accusing him. Okay, let me see if I got this right here. Defense counsel decided to ignore Hook, refuse to take his calls, and then apparently did respond to his voice and electronic mails in a disrespectful manner, violating the rules of professional conduct and civility. The unfortunate byproduct of this stonewalling were the alleged angry and inappropriate words directed at them, Mr. Klee, in conjunction with trying to resolve this case, which were nonetheless privileged under civil code. Coarse or offensive language used privately between counsel during litigation and settlement discussions are no basis for placing a hold on depositions, dismissing the action, or disqualifying plaintiff's counsel. On the contrary, Allstate's ex parte application is another example of bad faith litigation tactics in violation of FRCP 11. So his response is, again, no, you. And I don't get this, because even if defense counsel was upsetting to him, there's no justification for responding in kind. If the other attorney's behavior is so egregious, you file a complaint. Or at the very least, you can threaten a complaint if you are allowing a chance to cure and you don't believe that the egregious conduct rises to the level that it really needs to be a complaint unless it's not fixed. But you can never use those kinds of threats as a negotiating tactic. And it sounds like he wanted to respond stronger. He felt disrespected, so he felt that he could respond strongly. And I think he got that one wrong. I don't know. What do you think? He cites how ex parte motions are disfavored. That's true. We don't generally like ex parte motions. So the judge turned the ex parte motion into an order to show cause, and the parties will appear in court, I think, soon, like Monday. Yeah. Basically Monday, 13th, 14th, yeah. And we'll get to find out. Maybe we'll get the audio from that hearing. What do you think? Defendant's ex parte application is defective procedurally, should be summarily denied, because they failed to meet and confer prior to filing. The local civil rules require counsel to meet and confer prior to filing motions. Okay, so the argument might go something like this. He's saying we didn't meet and confer. Defense counsel might say, well, we already had these extremely disrespectful interactions with him. They were continuous and over a substantial period of time, at least days or weeks. And so we pretty much realized that he wasn't going to be respectful to us, and so why would we confer with him before filing a motion to have this dealt with? I mean, they did label it properly. They labeled it an ex parte motion. It was on the docket, and this isn't the kind of thing where they showed up to court in front of the judge and got a ruling without him. So it's not that kind of ex parte thing.
Wasn't he also threatening them? Like maybe they felt threatened and they didn't want to.
Yeah, he said something about the one attorney's wife and that he knew where they live, and it was really creepy. Allstate then filed no declaration describing a conference or attempt at informal resolution, and so he doubles down with this meet and confer rule, and then he says there's no evidence of good cause for relief. Wow. I'm guessing, let's see, before I read it, I'm guessing it's because it's confidential. Ex parte applications are not intended to save the day for parties who have failed to present requests when they should have. The use of foul language during settlement on its face is not an extraordinary circumstance that requires court intervention. And it appears that defense counsel contributed to the alleged situation by refusing to communicate with plaintiff's counsel without explanation. I had the same situation, man, with another attorney, but I'm not going to out them because I'm more respectful than that. But I basically had to explain to them that they had destroyed their own negotiation by breaking down into name calling and such. And then eventually they told me they were going to file a bar complaint against me because I wasn't negotiating with them. That's not how that works. There is no duty to negotiate. I do not have to negotiate. My client did not direct me to negotiate further, especially when my client saw the bad behavior, because I didn't hide it from my client like Hook did. So the other attorney, I mean, maybe the situation isn't resolved, maybe it is resolved, but the other attorney acted so offensively that I said, look, I can't negotiate with you if you're going to act like this. And they threatened a bar complaint. And then I said, well, now you've really crossed the line because I can't negotiate with you at all. If I change my position in negotiations as a result of your threat of a bar complaint, well, then I'm not acting in the best interest of my client, and I'm not a fiduciary, and that's a threat to my law license as well. So you go ahead and file your bar complaint, and I'm going to file one against you, and then we'll see whose is correct. And they decided they didn't want to file a bar complaint after all. So I didn't either. But if they had gone one step further, I was ready to, because that was clearly over the line. It also clearly altered that attorney's ability to work for their own client. So their client didn't get the settlement offer that we made a really good settlement offer too, and that their client didn't get the settlement offer because their attorney acted so heinously. I mean, we made the offer, and they have a duty to take the offer to their client, so I hope they did that. I don't have control over that, so that's on them.
It's just super unprofessional behaving that way. Like,
yeah.
There's just no other way around it. Like, it might not be against the rules of civil procedure to behave that way, but it obviously it is to threaten with a bar complaint in order to get your way. But the other stuff, it might not be technically against the rules, but it's a dick move, as they say.
Yeah, that's a complete dick move. And so now, is Allstate doing that? No, Allstate seems to be bringing to the court's attention the egregious and disrespectful behavior of the attorney. Now, keep in mind, there are other rules of professional responsibility and ethics, and you do have to conduct yourself in a respectful manner when discussing with other attorneys. And no, that doesn't always happen, but you're supposed to, and you can definitely get in trouble if you conduct yourself in a poor enough manner. See the Todd C. Banks story that we just dropped today. Go check out the Todd C. Banks story on YouTube. There was an attorney who got kicked out of court for far less disrespectful behavior. So if you imagine that if somebody said any of this stuff to an attorney in a court or to the court itself, way worse. So that attorney, the Todd C. Bank, got kicked out in less than 4 minutes. This attorney would have suffered way worse and might still suffer worse for their egregious behavior. Even if the use of offensive language during settlement litigation discussions was not privileged, defendant's motion fails because it is not supported by sufficient evidence, and because the evidence has to be something that's admissible. He says that the statement is inadmissible hearsay. Furthermore, the myriad settlement emails purportedly from the undersigned submitted with the defendant's application were not properly authenticated, and plaintiffs object to the admission or consideration of each and every document not properly authenticated. Okay, what could the court do? The court could request a properly authenticated document, if that's true. Like if it's not been signed by the client. But now we have those other declarations from Linda Oliver and Alan Baker. We have those declarations. And we're just going to skip ahead. He's saying that this was puffery or trash talk and was absolutely privileged because it's a settlement communication. I don't actually know how the judge is going to rule on this one, but I have a feeling that we are going to have a hearing on December 16th, 2019, which is Monday. And that'll be fun. What do you think of that? Let us know in the comments below. All right, well, that is our show. Thank you for joining me. I am Leonard French, your favorite copyright attorney. I appreciate you putting up with my set and trying to be quiet as my partner is sleeping in the room next door, so I hope I wasn't too quiet, and I certainly hope I wasn't too loud to sleep the slumbering Loch Ness monster, as Brandon has recently described her. So thank you very much to all of our supporters. This channel would not be possible without your direct financial contributions on patreon.com/ljfrench and sponsors.com/law. Thank you to our December $50 plus supporters: Aspernari, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Michael Pearce, Spirit Bear, Jan Negrey, Daniel Perez, Snorre Wisotzky, Blackleaf, Joe Tyson, Benjamin Hitov, Stephen, Rumble in the Bunghole, and Cute Grills in your area. Thank you very much to all of our supporters. The $50 and $5 plus supporters will be scrolling on the screen in front of me, and you will all appear in the description of the videos. Thank you very much for joining me. Thank you very much for watching. Thank you for your support. I love you all. I'm Leonard French, your favorite copyright attorney. Have a good one. Bye.